let's get on this real quick. And hold on just a second. There we go. That's better. All right. So we're going to get into medical, legal, and ethical issues. And what we're going to do is just apply our fundamental knowledge of all of these. And we're going to go through each one of them so that you understand what the medico, legal, and ethical reasoning is behind EMS. Okay, so intro. A basic principle of emergency care is to do no further harm. Kind of obvious, right? At least you would think so. Obviously, there's a slide in here and there's a phrase in here that talks about it because someone didn't do what they were supposed to do. So litigation against EMS will likely increase due to wider availability and more complex care. So we're supposed to be very knowledgeable of everything that we are providing care for in the field, right? So providing competent emergency care that conforms to the standards of care will help you avoid civil and criminal actions. And we're going to talk about all of those in just a second. Also consider ethical issues. So what are ethics? Well, those are our principles, either personal, societal, cultural, that determine what's right and wrong. Okay, what is right to you? What is wrong to you? And even when emergency medical care is properly rendered, there are times when you still may be sued. Administrative action may be brought against you if you don't follow EMS regulations, okay? All right. Make sure I got all of those. Now let's talk about scope of practice, okay? Now I'm talking to EMTs and I'm talking to advanced EMTs. Those are two different scopes of practice here. So guess what this means? Stay in your lane at all times. Stay in your lane. We don't go outside of our scope of practice. What is the scope of practice? That just outlines the care that you are capable of giving, what you were supposed to give at any given time. Okay, EMTs do not start IVs. Advanced EMTs do. Okay, EMTs, we're going to get into that in just a second, okay? So these are usually defined by a state law, and it even is further defined by med control in our protocols and our standing orders. And it just kind of gives us permission to do what we've been trained to do. And without that permission, you don't do it. So our medical direction authorizes care.
I don't see nothing on the slide. Like as you turn in the slide, it's blank.
So med control, med directors authorize care via a telephone or standing orders. And you have offline are our standing orders or protocol, and then online is telephone or radio. That means that they're on the line. They're giving you information. Okay. Carrying out procedures outside of our scope of practice may be considered negligent or of a criminal offense. And so scope of practice is different from standard of care. You need to understand that. You and other EMS responders have a legal responsibility to provide proper care and to report problems to your medical director immediately. Okay, yes, good. Thank you, Mark. Okay, so standards of care, what are those? That's a manner in which you are required to act and behave. You must be concerned about the safety and welfare of others when your behavior has the potential to cause harm. What does this mean? Generally, we need to be concerned, okay? Obviously, under given circumstances, we have a legal duty to act, but we need to be concerned about the safety and welfare of our patients, right? We also don't want to harm them. So, standards of care was established by published medical research, local custom. That's how a person with similar training and experience would act under similar circumstances. And the law, which has your statutes, ordinances, administrative regulations, and case law. And then you obviously have EMTALA, and that's Emergency Medical Treatment and Active Labor Act. There's a lot that goes into EMTALA. I'm not going to go over it tonight, okay? Professionalism and institutional standards. So you're going to have like AHA. They change the CPR standard. They change that every few years. State regulatory agencies are also involved in this. Then you also have standards imposed by textbooks. That's why you have the different editions, because we find different ways to do things, right? EMS enabling legislation and standards imposed by states, and those like your medical practice acts and certifications and licensure. Now, let's talk about negligence, because this is pretty important. Failure to provide same care that a person with similar training would provide. So if I have two EMTs and one gives shoddy treatment and the other one gives the treatment they're supposed to, who do you think's in trouble? Well, it's this guy over here. He should have done that. That's considered negligence. Okay. So gross negligence is when they conduct that constitutes a willful or reckless disregard for duty. And you have to have three categories right here that have to occur for negligence to occur. So you have your malfeasance, and that occurs if you perform an act that you're not authorized to do. So say an EMT starts an IV. That's bad juju. Don't do that, okay? Nonfeasance occurs if you perform an act that you are legally permitted to do, but you do so in an improper manner. So an advanced EMT starting an IV and they blow the vein, but they never take the catheter out. And so the patient bleeds out and dies. There you go. That's one. I'm not going to try to say that. Not doing it. I don't speak Spanish. I don't speak Latin, and I speak English and bad English. But what this is defined as the thing that speaks for itself. What this means is, under this theory, the injury could only have been caused by negligence. So in the case of what I just told you, the advanced EMT starts an IV, they blow the vein, but they leave the catheter in, the patient bleeds out. Well, first and foremost, if the advanced EMT had not started that IV, had not blown the vein, and had not left the catheter in there, those three things right there caused the negligent act, and the patient passed away or had a very bad situation. Okay, so the thing speaks for itself. All four of the following elements must be present for negligence to apply. You have a duty. That's pretty easy. A duty is just an obligation to provide patient care. And then you have your breach of duty. So what is a breach of duty? Well, if you have a duty to act, a breach of duty occurs when the person accused of negligence fails to act as another person with similar training would have acted under the same or similar circumstances. And this just literally means you're doing less than what you're supposed to or what you've been trained to do. It's even an error of omission. It's you failed to do X, Y, Z for this patient. One of the examples given in the book is you failed to splint an extremity. That error right there is bad. Okay, damages. Okay. The objective of a civil lawsuit is usually some sort of compensation when the patient is physically or psychologically harmed in some noticeable way, right? So although physical injury is usually part of a lawsuit for medical negligence, patients can also claim damages for emotional distress, loss of enjoyment of life, spousal consortium, loss of household services, future capacity to earn money. And then you have causation or proximate cause. And that's a legal term that, in the sense of medical malpractice, essentially considers whether the alleged harm to the patient would have occurred but for the negligent act. If the injury would have still occurred regardless of the alleged act of malpractice, then no valid claim exists. And if you have a legal duty to act and abuse it, causing harm to another individual, then you, your EMS agency, med control, med director can all be sued for negligence. By the way, I'm going to go back to this one. That's important for you to know. Okay. Abandonment. This is when you terminate care of an advanced EMT or EMT without the patient's consent. You just walk away. You leave them at the scene. You shouldn't even be calling 911 by. That's bad. Okay. Nobody does that. Well, no, people do that, obviously, because abandonment is a thing. So once you've started care, you have assumed this duty to take care of this patient, right? Until someone of equal or higher training comes along and takes care of them. And then you just give them the responsibility of the patient, right? Well, when you don't do that, that's considered abandonment. By the way, you can be considered abandoning a patient if an advanced EMT gives control of patient care over to an EMT or an EMR. Don't go backwards, okay? A legally and ethically serious matter that can result in civil or criminal liability, and it can happen anywhere between the scene and the ED. Okay, you can literally abandon a patient in the hallway. Okay, assault and battery. A lot of people get this mixed up. Yeah, a bat hits you, right? I love the KISS method. Keep it simply sweet. I don't say the other word because that has a negative connotation, and we have enough negativity in this world. So we keep it simply sweet. But in this case, bat hitting you is not very sweet, and that's why it is the unlawful touching of a person is battery. So if you hit me with a bat, that's against the law, right? So battery. Keep it simply sweet. An assault is just threatening someone, giving them cause for fear of bodily harm without their consent. And that can take on different areas. Kidnapping and false imprisonment. Yes, we can go to jail for false imprisonment, especially if you take a patient from their home or wherever from the scene and you take them to a hospital that they don't want to go to and they say, no, that's kidnapping. Unless, of course, there are other things in place, like if it's an MCI and they have to go to this specific hospital because it's the next on the list or something like that. Okay, there are other things, but I'm talking about you are seizing, confining, abducting, and carrying away by force. Okay, and I'm not talking about a suicidal patient who is ready to kill themselves and you need to protect them from different things. That is not what I'm talking about. I'm talking about just someone having a heart attack and you're like, nope, Granny, let's go. Get in the back of the truck. A false imprisonment is much more likely than kidnapping, but it can be a charge that you do get if you falsely imprison someone. Defamation, slander, and libel. Okay, so defamation is intentionally making a false statement through written or verbal communication that injures a person's good name or reputation. So, to defame someone's character, right? Libel, that's written, slander is talking. So those are the only differences. Good Samaritan laws and immunity. So Good Samaritan laws are based on the common law principle that when you reasonably help another person, you shouldn't be liable for errors and omissions that are made while giving good faith emergency medical care. Now, most states have Good Samaritan laws, and those do not protect you from lawsuits, and they vary from state to state. Good Samaritan laws vary from Texas to Mississippi. Some people, well, I mean, from all over America, but Louisiana and Alabama are similar, but Texas is a little different than Mississippi. Some provide protection for anyone who stops to render aid during an emergency. Others only provide protection for those with no medical training at all. Okay, so know your state before you do anything. Okay. Another group of laws grants immunity from liability to official providers, such as EMTs, advanced EMTs, and paramedics. They vary from state to state. Once again, you may want to look those up. They do not provide immunity when injury or damage is caused by gross negligence or willful misconduct. So once again, if you're going to stop on the side of the road to help somebody, you better have the equipment with you. You better be able to handle whatever care they need, okay? In the United States, there's something called sovereign immunity. And that has taken the form of legislation that identifies only limited types of lawsuits that can be filed against government agencies. Hold on just a second. I'm going to answer that, Jared. EMS personnel working for government agencies have some governmental immunity for their actions. Governmental immunity generally applies only to EMS systems that are operated by municipalities or other government entities. Okay, so that's probably not you. How do refusals play into that? A refusal is something that is giving consent to refuse. A Good Samaritan law, that's completely different. That's when you pull over on the side of the road, you weren't called for a duty to act, and you see someone that is in need, and you help them. So a couple slides back, you talked about abandonment. We collect patient refusals, but we're also told that refusals aren't worth the paper they're printed on. Depends on what kind of lawyer you have. I'm just going to go ahead and tell you that if you have a signed document from a patient and you can provide evidence that they were A&O times 4, which is alert and oriented, times person, place, time, and event, and that they are cognizant, not under any duress or under any type of alcohol or any mind altering uh, drugs, then it's fine. But any lawyer can tear apart anything. So that's a thing too. I have ironclad refusals. Ironclad refusals. Where my refusals are twice as long as my normal PCR because I am frightened of lawyers. So get really good at writing your refusals and talking about the things that you know for a fact. Like if someone has drank one beer, we all know one beer is not going to make you drunk, right? But in the case of law, if you have had any alcohol in your system, then that means that you are impaired to make a judgment. So therefore, that person cannot refuse treatment. With that said, I don't lie on my PCRs either. So there's a lot to that. That's a whole side note, but we'll talk about that maybe eventually. So laws vary. Always consult with your med control. Now, we're talking about consent again, real quick. That's just permission for treatment. Every conscious, mentally competent adult can be started. If the patient is alert, rational, and capable of making an informed decision, he or she has the legal right to refuse care. Here you are. Okay. Now let's break that apart. They're alert, rational, capable of making informed decisions. Those things have to be there. Okay. So if you have a patient refuse medical care, then you may not have to care for the patient, but doing so may be grounds for criminal and civil action. So you have to worry about getting that consent or the permission to refuse, one of the other. It does require decision-making capacity. So this is why children cannot make that decision for themselves. They can't. It has to be an adult, or it has to be an emancipated minor or a pregnant minor child can make an informed consent. Talk to the patient to find out if the patient understands what's happening to him or her, obviously. So you have express consent. Patient acknowledges he or she wants to go to the hospital. They want to be treated. Yeah, let's go. Let's go ahead and take me to XYZ hospital. And it may be verbal, it may be nonverbal, and patient must provide some sort of informed consent. They describe the suspected illness and injury, treatment that you would have administered, and potential risks, and advise the patient of consequences of refusing treatment. But when we're giving express consent, it's like, hey, I want to go to the hospital, right? They must be that legal age and rational decision-making capability. Okay, implied consent. Now, this one's appropriate when the patient is unresponsive, delusional, not A&O times 4, okay? Exhibiting an altered mental status is what that means, and otherwise incapable of making an informed decision. Okay, this is where we are taking over this patient's life and saying, hey, I know better right now than you do at the moment, and I'm going to take care of you, and I'm going to make those decisions for you, okay? Limited to true emergency situations. It may become a legal question later on. So document literally everything you do, every action, every question, everything that you've seen, all of it, document it. If it takes you 4 hours to write that PCR, it takes you 4 hours to write it, okay? But you make sure that you document everything that you can. But please try to get the consent from someone there, a spouse, a legal guardian, some sort of a relative, whatever. Now, refusal of care may also be implied, and implied consent no longer applies if the patient regains consciousness and appears capable. So we run into the people that have low blood sugar. You give them something to raise their blood sugar, and then they say, hey, I'm just not going to go to the hospital. So that's where the refusal of care is also implied at that point. Minors in consent, parent or legal guardian gives consent in some states. And so you have to look those up. A minor can give consent depending on the age and maturity. Married, pregnant, or emancipated minors or minor parents can give consent for their children, but they can't give consent for themselves. They have to have a parent do that for them. When they are no longer pregnant, they can no longer give consent for themselves. Obtain consent whenever possible in loco parentis and always in non-life threatening situations. Okay. So if it's true emergency, we don't have to worry about a consent at that point. We're going to treat the patient. The consent is just implied. So I'm not going to wait for a parent, guardian, caregiver, or anyone to come out in the street if a 4-year-old gets hit by a car while crossing the road. I don't care where they're at. Okay. This kid is hurt. Maybe they have an open fracture, or maybe they're unconscious. I don't care. We're taking them to the hospital, and I'm not going to pay for that later. That's okay. This is true implied consent at that point. Okay. An involuntary consent. It's an oxymoron because consent can never be involuntary. People use it incorrectly to refer to situations in which law enforcement or a legal guardian grants permission to treat someone who is under arrest or otherwise in custody. Maybe they're mentally ill, developmentally delayed, incapacitated, a minor, or for other reasons. So involuntary consent, it can never be actually involuntary is what we're trying to say. These are those people that are under arrest. Just because you're under arrest doesn't mean that you lose your rights to be involved in your treatment and what goes on with you or your medical decisions. Okay, just understand that. But if a prisoner refuses treatment, involve med control immediately, because at that point there's a whole lot of stuff that is above our pay grade. Okay. Forcible restraint, the act of subduing a patient to prevent harm, and applies to patients who are physically violent, present a risk to others, and in need of treatment. And you can run into a lot of these different types. It is legally permissible, okay, if they are a threat to themselves or others. And one thing you got to do is you got to consult med control for authorization. This is not one of those, I'm going to ask for forgiveness. Negative. You can lose your license, you can lose your certification, you can lose your job, you can lose your home. Don't do that. That is correct, Jared. Involuntary consent is an incorrect term, even though it is used a lot. Restraint without authority exposes you to civil and criminal penalties. And one of those is going to be like impersonating a law enforcement officer. It can be kidnapping, a whole bunch of different stuff. Okay. If the patient is responsive and the situation is not urgent, consent is absolutely required at that point. Now we have a right to refuse treatment. Of course, everybody does. If you're a conscious, alert adult who appears to have decision-making capability and a capacity to understand what's going on, you absolutely have the right to refuse treatment all day long. And you can even withdraw treatment at any given time, even if the result is death or serious injury. And I have been on those scenes before. Looked at a guy, I said, sir, it looks like you're not doing well tonight. And he says, yeah, I've been having chest pain for several hours. Put him on a 12 lead. He's having a STEMI. He decided to go see Jesus that night and not come with me. I had to leave him. I had no choice. It didn't matter what happened. And sometimes you will run into people that are like that. Okay. Such patients present you with an ethical dilemma, though. So should you? Should you not? Should you leave them alone? What should you do? So at that point, you're going to call med control and get them involved. Okay. If you leave a patient alone, then you risk being accused of negligence or abandonment if his or her condition does become worse. And you may even face charges of false imprisonment if you transport a patient against his or her will. So there's a lot going on. All of my refusals always state patient understand the risk up to and including death. Absolutely. Every single one of them. And I always put in there a little clause that states that patient was made aware that that they could die if they do not seek treatment. It doesn't matter if it's a hangnail. I don't care. You could die. That's the worst of the worst. Okay. Make sure patient understands potential risks, benefits, treatments, and alternatives, because if there are, then you need to make sure they know it. In order to refuse treatment, the patient must be alert and oriented to person, place, time, and event. When in doubt, proceed. Okay. Urge patients to go to other medical evaluations. How do you feel about the concept of implied consent when it comes to this? Patient confuses treatment or refuses treatment, then passes out. Yeah. So if they refuse treatment and then they pass out, then it's implied consent, and I'm going to put them in the back of my ambulance. That's all there is to it. If you wake up in the middle of transport, sorry about your bad luck, but it was implied consent and the law is on my side at that point. That's literally all there is to it. Even if I have a really great lawyer that's against me saying, well, you knew that this patient didn't want to do X, Y, Z. Well, I also know that if they're unresponsive, then that means that they don't have an airway and that they could die. And then that would mean tantamount to murder. So therefore they got put in the back of my ambulance. There's a lot of different things that we can go over with that. I always make sure to include everything that happened prior to the unresponsive nature and then everything after. Especially in cases like that. State laws generally do not permit a parent or legal guardian to deny treatment for a minor, so watch out for those. And if you're unable to obtain consent, document any findings that you have, period. Literally document everything. Note how much time you spent attempting to provide care. The report and patient signature should be witnessed, and make sure it's witnessed outside of, if you can, like, let's say there's law enforcement, pardon me, or fire department on scene, get one of them to witness it. Make sure they put their badge number or their FD number, and make sure that like it's legible at that point. And just because you know someone today does not mean that in 30 or in 20 years that you know them again. Okay, just trust me. All right, advanced directives. Specify treatment if a patient becomes unable to make decisions. These are in cases of like living wills, DNRs, organ donors, things of that nature. So to be valid, it has to be in the state patient's medical problem, have signature of patient or guardian, and have the signature of at least one physician. And states vary state to state on certain things. So you have to check those out. Some do expire, some do not. So it literally is a state by state basis. Even with DNRs, you must provide supportive measures. Okay. Not going to get into this, but if you have a DNR, but your sugar is too high, that has nothing to do with your DNR. And let's say your sugar is, I don't know, 800. That doesn't mean that you get to leave them on scene to die slowly. That's negligence, okay? That's bad. Don't do that. If a patient has a DNR because they have cancer and they get into a car wreck and they break their leg, that doesn't mean you leave them on scene bleeding out, right? Same thing, okay? Patients may have healthcare proxies, so there may be a durable power of attorney, and that person, they're going to be the ones that are going to be calling the shots at that point, especially if they're named, and usually they're right there on scene or they're within a phone call, okay? Read carefully to make sure that you're not hurting something in there, okay, that's going against their wishes, right? Ethical principles and moral obligations. And guys, we are almost done, so just bear with me. Ethics is the philosophy of right and wrong, moral duties, ideal professional behavior. Remember, ethics come from everything that we hold true. It comes from how we were reared. It comes from the culture that we have. It comes from our religious aspects. Morality is a code of conduct affecting character, conduct, and conscience. And then applied ethics is the manner in which ethical principles are incorporated into professional conduct. And then on here, it says Table 3-1 lists the guidelines to assist in ethical decision making. So go ahead and make sure you look at that. Okay, you must meet your legal and ethical responsibilities while caring for your patient's physical and emotional needs. Really? You don't say. Practice absolute honesty in reporting. What does this mean? No matter what it is, put it in there. You made a mistake, put it in there. You didn't make a mistake, but your partner did, put it in there. It is what it is. Everyone does that. We are human, and sometimes our mistakes do kill people. Keep that in mind. Keep accurate records all the time and maintain a mastery of skills. If you miss 15 IVs, then you need to go back and start doing your skills again, okay? And advanced EMTs will encounter ethical dilemmas along with EMTs as well. Failure to live up to the legal or ethical standards can result in criminal and or civil lawsuits. Let's talk about confidentiality. And I'm just going to get off of this for like 2 seconds and talk about John Travolta's son, Jed, died on, I want to say it was ski slopes or something like that. And the 2 paramedics that worked on Jet, the 2 paramedics that worked on him, they talked. They told everybody everything. They talked about John Travolta. They talked about, like, it was awful. They talked about the treatment. It got on social media. Those guys are under the jail, rightfully so. You know, you can't just go out and sell to the highest bidder when it comes to stuff. And just because John Travolta is a star doesn't mean that his son should be preyed upon in the National Enquirer, okay, or anybody for that matter. That's just not okay at all. So keep that in mind when we talk about this. Confidentiality is such a huge deal. I don't want anybody telling everyone if I have a communicable disease. I don't want everyone knowing, okay, I do have ADHD. I'm not ashamed of that. But there are people out there that really get their feelings hurt if they find out that someone else offhandedly mentioned, oh yeah, they have ADHD. They take Adderall for it or whatever. People get really upset about that. So don't, just don't. Keep your mouth shut, okay? Confidentiality includes assessment findings, treatment, diagnosis, mental and physical condition. It even covers what hospital you take these patients to, okay? Generally, records may be released only if patient signs a release. Awesome. There's a legal subpoena. That's a necessary thing. Third-party billing. Okay, that's a thing, right? And to health agencies concerning diseases that may affect the population. So like if they have like TB or hepatitis, it automatically goes to a third party that is going to deal with that, okay? Events such as seizure activity that may be reported to the Department of Motor Vehicles. That's another one. And of course, in cases of rape and abuse. Improper release of confidential information or release of inaccurate information can result in liability. Remember, we talked about libel, which is written, and slander, which is spoken. And document only objective findings, not personal opinions. Okay? Don't call the person a bad name. Don't do that. Patient states, I don't like you. Patient then went on to state, I'm going to harm you. Okay, put it in quotes, whatever they said. Don't say, oh, that patient was acting a whole booty. Okay, don't do that. Okay, that's not professional. And B, you look like a laughing stock. Okay, it's just ridiculous. Put in there what happened, because objectively, when a judge looks at it, he's not going to laugh. He's not going to, or she's not going to laugh and think, oh, that's cute, that's funny, oh, whatever. No, they want a painted picture of what actually happened. No need to embellish is what I'm getting at. Okay, HIPAA, that's HIPAA, Health Insurance Portability and Accountability Act, and that contains a section on patient privacy that strengthens our privacy laws. It started in 1996, and I tell you what, it has changed quite a bit since then. And it safeguards our patients' confidentiality, and it provides a guidance on what information is protected, responsibilities regarding that protection, penalties if you breach that, and all patient information is protected through HIPAA. Pardon me, y'all. Okay, records and reports. You can compile records, compile record for all incidents involving sick and injured patients, and important safeguard against legal complications. So if you have a patient, period, you need to have a record for it, right? The absence of a record or a substantially incomplete record may mean that you have to testify about the events, your findings, your actions, all by relying on memory alone, which, by the way, any lawyer can kick your rear on cross-examination on that, okay? So court's perception of records, if an action was not recorded, it was not performed. So you guys are going to hear this more than once in your career. If you didn't document it, you didn't do it. If you didn't document it, you didn't do it. This holds true all the time, forever, for the rest of your life in medicine. That holds true. Okay. Incomplete or untitled reports are evidence of incomplete or inexpert emergency care. Guys, most of everything is on the computer now. There's zero reason for you to misspell a word ever. And if you do, you'll be ripped apart on the stand. So if you don't know how to spell a word, look it up. We have Google. Okay. And then we also have NEMSIS, which is the National EMS Information System. And that one provides the ability to collect, store, share, and analyze standardized EMS data throughout the United States. And so this database literally improves our speed and accuracy of data collection. And it also helps us with early warning of disease outbreak. And another thing that does really well is we can pull different types of calls from this, like a trauma-related call, like, our backboard's really good for us or not. Okay. Mandatory reporting requirements, all states have this, okay? And so if you have neglected or abused children or of older adults, domestic violence, and you guys can read, all of these have to be mandatorily reported. There's no ifs, ands, or buts about it, okay? A gunshot wounds is another one that should be on here. Scene of a crime. Notify the dispatcher immediately if you believe a crime was committed at the scene. Remember, if it's not safe, leave. Provide care, but don't disturb the scene more than necessary. That's important for you to know. Okay, guys? While providing care, if you disturb the scene, don't disturb the scene, but make notes, even drawings of the position of the patient. If there's a weapon, if there's or any other objects that may be close to them, make sure that you draw that out or something, that way that people can see it. Don't cut through holes in clothing from gunshot wounds or knife stab wounds. Confer periodically with local authorities and be aware of actions they want you to take at a crime scene. So they may want you to tiptoe in a certain way instead of going straight to a person. They may make you go in at a certain angle. Okay, just do what they ask you to do. Pardon me. If there's any chance, attempt resuscitation, and if the death is obvious, just cover the body and prevent its disturbance. Okay. There are signs of physical death that just physicians determine cause of death naturally, but there are signs that are presumptive or definitive. So death is generally defined as absence of circulatory and respiratory function. In many states called it brain death provision. So let's go over what those mean. In the absence of physician's orders, if the body is still intact and no definitive signs of death are present, then initiate emergency medical care. Now, a patient is only dead and warm, like if they're cold, they are not dead. They have to be dead and warm is what I'm getting at. So you will continue to work that patient if they are hypothermic until, thank you, warm and dead. I don't know why I was tripping over my words so bad. But thank you. You knew what I meant. Hypothermia, literally decreases our metabolism. This decreases the necessity for oxygen in our system. That decreases the ability for us to have to breathe. And so some people look like they're dead with a heart rate of 10, but they're really not. So that's why it's warm and dead. Okay. Presumptive signs of death are generally adequate, and particularly after like severe trauma or long-term illnesses. These are not cases of like sudden death. So you will see these, okay? And here's some physical signs. You have lack of pulse. This is now presumptive. Remember, just because it's a lack of pulse doesn't mean they're dead. Remember we talked about warm and dead? Okay, hypothermia, think about that. No eye movement, once again, hypothermia. No blood pressure, once again, let's get back to hypothermia. Cyanosis, hey, I mean, you know, bluing of the skin is pretty bad, period. But I mean, hey, if they're hypothermic, then they're gonna have blue of the skin, right? Lowered body temperature. Hey, didn't I just talk about hypothermia? By the way, if you don't know what hypothermia is, it's below normal temperature. Definitive signs. You cannot live without a head. Okay, so you have a decapitated person, they're dead. Dependent lividity, that's what you see here. That is where the blood pooling goes to the lowest portion of the body. This patient has been turned on their side to get this picture. Okay. Rigor mortis, that's when the body has gone into stiffening of the body muscles, and that's just caused by chemical changes within the body itself. And it's first going to start like in your jaw, and it's going to extend downward. You're going to get it right here in your hands too. Your fingers are going to be another person or another place that you're going to see that faster. But it occurs between 2 and 12 hours after death. And then you have putrefaction, which is exactly what that sounds like. It is the decompensation of body tissues, and they are putrefied. I live in the South, where it gets very hot and humid, and there are times when we go on welfare checks and we get out of the truck and we immediately get right back in because we don't have to go inside. We already know what happened inside because of the smell. So this occurs between 40 to 96 hours after death. And yeah, you still have to go back and you still have to go inside. Still have to at least look at them. Medical examiner cases. Now, they must be notified if there's a death at the scene, unknown cause of death, suicide, violent death, or death from an accident, poisoning, suspicion of criminal act, or death of a child. And that's any death of a child. It doesn't matter if they have had a long-term illness or not. Okay. Organ donation. Guys, if you get called to the scene of an organ donation, you will call your hospital and allow them to know, like, hey, this person is an organ donor. I mean, even when you get there. But this is just an expressed wish of the person. Consent is voluntary, informed, evidenced by donor card or driver's license. Of course, we're going to save the patient's life. We're not going to allow them to pass on simply because they're an organ donor. I don't know who started that crazy rumor. I've never met anybody that has said, hey, let me look at their license before I save their life. Medical identification insignia. Now, these are going to be like your bracelets, your necklaces, things of that nature that they're going to tell you like what they have. And a lot of them are allergies. And a lot more now are like, hey, it's an epilepsy thing. So you'll see like a purple band, or even diabetes, things of that nature. Allergies, of course, are on there. And then there's even DNR orders that may be there. Now you can check phones for medical information. Yes, absolutely. ICE in case of emergency. And under the in case of emergency, especially if you have like an iPhone, it lists like your allergies, your medications, and any past medical history that you have that's necessary for them to know. So it's very good to have. Okay, so that's that. And I am going to stop sharing this one. All right, guys. Anybody got any questions? Oh, hold on just a second. Let me stop recording.